Welcome back, future criminologists. In this video, I will be discussing the exclusionary rule and the fruit of the poisonous tree doctrine. The exclusionary rule principle. It is a principle which mandates that evidence obtained from an illegal arrest, unreasonable search or coercive investigation, or in violation of a particular law must be excluded from the trial and will not be admitted as evidence. The principle judges the admissibility of evidence based on how the evidence was obtained or acquired and not what the evidence proves. When is the exclusionary rule principle applicable? The principle is to be applied only if it is so expressly provided for by the Constitution or by a particular law. Even if the manner of obtaining the evidence is in violation of a certain law, but the law does not declare that the evidence is inadmissible, then such evidence will be admissible. For example, the accused claimed that the information about his bank accounts was obtained in violation of the Secrecy of Bank Deposits Law or Republic Act 1405 and moved to have them be excluded as evidence. However, Republic Act 1405 merely provides that it shall be unlawful for any official or employee of a banking institution to disclose to any person any information concerning their deposits. Nowhere in the said law declares that such unlawful disclosure shall render the evidence therefrom inadmissible in court. Derivatives of excluded evidence. If evidence that falls within the scope of the exclusionary rule led law enforcement to other evidence which they would not otherwise have located, then the exclusionary rule applies to the newly discovered evidence, subject to a few exceptions. The newly discovered evidence or secondarily excluded evidence is called fruit of the poisonous tree. Now we are going to discuss the fruit of the poisonous tree doctrine. The fruit of the poisonous tree doctrine is an offshoot or extension of the exclusionary rule to make evidence inadmissible in court if it was derived from evidence that was illegally obtained. It is based on the principle that evidence illegally obtained by the state should not be used to gain other evidence, because the original illegally obtained evidence taints all those subsequently obtained. The poisonous tree is the evidence seized in an illegal arrest, search, or interrogation. The fruit of this poisonous tree is evidence discovered because of knowledge gained from the first illegal search, arrest, or interrogation or violation of a law. Application of the doctrine. The fruit of the poisonous tree doctrine applies to both physical evidence and live testimony that was obtained through illegal means. What is the relationship between exclusionary rule and the fruit of the poisonous tree doctrine? The exclusionary rule applies to primary evidence. The fruit of the poisonous tree doctrine applies only to secondary or derivative evidence. There must first be a primary evidence which is determined to have been illegally obtained. Then, secondary evidence is obtained because of the primary evidence. Since the primary evidence is inadmissible, any secondary evidence discovered or obtained because of it may not also be used as evidence. For example, Jose, a suspect, was forced to make a confession where he revealed he took shabu from the room of Pedro. Based on this knowledge, The police went to the house of Pedro and searched his room and found the shabu. The confession of Jose is inadmissible because of the exclusionary rule. It is the poison tree. The shabu is inadmissible because knowledge of its existence was based on the confession. It is the fruit of the poison tree. Kung ano ang puno, siya ring bunga. Pero kung ang tatay mo ay magnanakaw, nasayo na yun kung gusto mo ring magnakaw. Now we go to the exceptions to the doctrine, which are also the exceptions to the exclusionary rule. 1. Independent source doctrine. 2. Inevitable discovery doctrine. 3. Attenuation doctrine. 4. Good faith exception. Independent source doctrine. Evidence that is acquired through an independent source is not fruit of the poisonous tree. It is not required to be excluded. For example, an officer entered the house of Pedro illegally without a valid search warrant to search for illegal drugs. Later, a search warrant was obtained based on the valid confession of Jose that the illegal drugs was hidden in the house of Pedro. Here, the evidence need not be excluded and thus admissible in court. The evidence was obtained based on the valid search warrant and not on the officer's illegal entry. Inevitable discovery doctrine. The inevitable discovery doctrine allows admission of evidence that was discovered in an unlawful search or seizure, if it would have been discovered in the same condition anyway by an independent line of investigation that was already being pursued when the unlawful search or seizure occurred. This means that the police would have found the evidence even without the illegal search. Attenuation doctrine. In cases where the relationship between the evidence challenged and the unconstitutional conduct is too remote and attenuated, the evidence may be admissible. Good faith exception. Under the good faith exception, evidence is not excluded if it is obtained by officers who reasonably rely on a search warrant that turns out to be invalid, or when the officers rely on a statute that is later invalidated. To end, please subscribe to our channel and stay tuned for more videos.